To Parliament now, where the Justice Kweku Boafo is set to appear before Parliament's Appointment Committee today for his vetting session, which was delayed by petition. He's the last of President Mahama's Supreme Court nominees to be vetted. The delay stemmed from a petition by one Anthony Kwabena, who accused Justice Ackaah Boafo of judicial misconduct. Well, we spoke with the Majority Chief Whip Roxanne Nelson Dafiamapo, and member of the Appointment Committee, who gave details of this on our desk yesterday. We'll play that later on. Do we have James on the line so we can quickly speak to James on the current situation in Parliament? All right. So we do not have James now, but let me come to you, Prof. So far, the vetting process since this week, what do you make of the process so far? The judges that have appeared, at least 6 of them out of the 7, the last one is being vetted today. Their performance before the vetting committee, and also the vetting committee members, how have you seen them perform?
Well, so far, I think it's been quite all right. The nominees, I think, generally have acquitted themselves before the committee. The vetting itself, the process itself, as can be expected, is always interjected with some kind of what I'll call comedies and that kind of stuff. But I think the questioning has been on target. Because look, the positions they are going to occupy, once they get it, is for life. And I think recalling the experiences of certain of the performance of certain justices, people I think are getting more interested in this. So if, for instance, the last one that is going to appear today, somebody petitioned, and hopefully the committee found a way to investigate the accusations against this Justice Boafo. Now, if they come back to say, look, we did the investigation and we didn't find anything of substance, then of course the process goes on.
Well, Prof, so, let's bring in Roxanne Dafiamapo giving details of that particular petition, and then we'll come back to you.
The tenor of the petition and the essence was that there was a matter before Justice Ackaah Boafo, which he determined and entered judgment. And the petitioner claimed that as a party in that case, Justice Ackaah Boafo abused him verbally in the judgment.
Okay.
Now, we have perused the petition. We have also perused the judgment. What we have discovered is that Justice Ackaah Boafo actually quoted from an exhibit adduced by the petitioner as a party in the case. It is the content of that exhibit that he quoted verbatim as part of the judgment to make a point. So if the contents of the exhibit that he quoted were offensive, then those were not the words of Justice Ackaah Boafo. They were the contents of exhibits that form part of the court's records, which he relied on to make a point in some part of the judgment. But we'll deal with this matter. That is why the chairman and all of us saw fit to withhold his vetting until we deal with the petition and establish the merit or otherwise of it to be able to make progress.
And that was the explanation Roxanne Nelson Dafiamapo was giving shortly before that petition was dismissed, Prof.
If what Roxanne has just explained is the real the case, then I don't see why that should stop someone from getting appointed as Supreme Court judge. I haven't seen the record, but based strictly on what I just heard from Roxanne, I don't see anything wrong with that. I think the process should proceed.
Right.
Because I don't think it's enough substance in this one to stop the appointment of the judge.
And also, I mean, the judges that have come and gone already, for instance, Justice Jamafe has also indicated that judges must declare their assets. What do you make of that?
Oh, I love it, especially in the context of corruption that seems to permeate every aspect of our public life. And of course, there's history of corruption within the judiciary. Every Afrobarometer report over the past decade or so seems to tell us that the judiciary is one of the institutions, a state institution that is corrupt. And you remember, not too long ago, a certain chief justice, based on analysis, investigations, had to reprimand and, but in some cases, even sack judges. So nobody will dispute the fact that there is corruption in there. And if by getting them to declare their assets as a way of checking that, why not? We should have it. After all, the other arms of government, appointees, are subjected to the same kind of thing. It's unfortunate that has to come to that, but I think that's, in fact, is done in some other countries. And that's also to ensure that the judiciary protects its own integrity by constantly reminding members that, look, your assets have been declared. But having said that, let me add that the asset declaration by themselves do not mean much, because over the past 30 years, assuming all appointees have been declaring their assets, we don't have a single case of someone whose assets were evaluated at the end of their tenure for pronouncements to be made. So what is the use of that? That's why some time ago, people are still agitating for a kind of a review of that to ensure that at the end of your tenure, there must be another review and declaration. Okay? Yeah. And even intermittently, yearly, making sure the monitoring authority, if there's one, reviews them and let the public know. So my point is that, sure, it would be good to have them to declare, but I don't see the effect of that, since for 32 years, there's not a single case of anyone declaring the assets and at the end of the tenure, getting to know that something happened or nothing happened.
I would like to hear your thoughts about the presidential succession, but let's go to Parliament now and get the very latest from James Aveji, who is there for us. James, what can you report? James?
Yes, Mami, I can hear you.
Great. What's the latest from Parliament? I see that there are empty chairs.
Yes, so, I mean, the sitting is expected to, but I said that we have
so, I mean, the sitting is
usually the members' leadership of the House will usually go to conclave meeting ahead of...
leadership of the House would usually go to conclave meeting ahead of the main proceedings on the chamber of the floor, and also have some conclave meeting amongst themselves as far as the vetting is concerned. And so usually those two meetings sometimes delay the proceedings, but by 11 p.m., 11 a.m., 11:30 a.m., as we have witnessed in the past 3 days, the vetting should start. But I must say that while we were setting up, a number of chiefs have been arriving at the forecourt of Parliament who would be coming as guests to support Justice Kweku T, Ackaah Boafo in his vetting process. We know all of the controversy that surrounded his vetting process in the last few days. He was supposed to be vetted 2 days ago as the 7th nominee of President Nana Addo Dankwa Akufo-Addo, who was nominated by Nana Addo Dankwa Akufo-Addo to the Court of Appeals, and then John Mahama nominating him as part of the 7 justices to go to the Supreme Court. But on Wednesday, when the vetting of Justice Janapari ended, it was clear that his vetting would not come on at the time. We were not given any specific reason as to why his vetting would not come on, but we were later informed about the fact that there's been some petition on the back of his nomination and all of that. And so yesterday at about 5 p.m., we got the confirmation that the petition has been dealt with. It did not find favor with the petition committee as well as the appointment committee. Those two committees, leadership of those two committees are the ones who worked on that, and that petition raising issues of abuse as well as judicial misconduct by that private citizen did not find favor in the eyes of the two committees. And so he has been cleared now to go ahead with the vetting process. And so we want to believe that by 11 a.m., the vetting should start. Between 11 and 11:30 a.m., the vetting should start because the House would also be sitting at 2 p.m. To see to the day's activities. And so that's the latest here. The chiefs and people are arriving. The leadership of the committees are currently, as we understand, in conclave meeting ahead of the vetting process. Mamiesi.
James, have you set sights on Justice Ackaah Boafo himself?
I haven't seen him around yet. Usually there's a holding room that the clerk of parliament would usually hold them. And when the committee sits properly, the guests would also take their seat. And so the nominee usually is the last person to be ushered into the committee room. And so I'm yet to set my eyes on him, but we look forward to seeing him and how he would approach the varied array of questions that the committee members would be testing his minds on.
That update there, James is in Parliament for us, and he'll be bringing us the very latest in this particular vetting of Justice Kweku Ackaah Boafo. And I still have with us Professor Boafo. I beg your pardon, the name keeps escaping me. Prof, I hope you're still with us.
Yes, I'm with you.
We are human. So sorry for butchering your name
That's all right.
on live television. But I wanted to know from you, you know, Justice Dominic J, during his vetting, also stated that Ghana's presidential line of succession should be restricted to the president, the vice president, and as well as the Speaker of Parliament, and should be excluded, you know, of the Chief Justice. That seems to be interesting. What do you make of that? You know, for him, the Chief Justice shouldn't be included, even though that's what it is in our laws.
I think it's an interesting proposition because in the country, you have the president, the vice president. So in the absence of the president, there's a vice president to step in. In case the two of them are out, then the speaker steps in. So the assumption is that there could be an occasion when the three, the president, the vice president, and the speaker, will be out of the country or incapacitated in whatever way, and therefore the Chief Justice steps in. But I think that's a bit far-fetched. I think the president and the vice president, in fact, in most cases, unless there's a ceremony where both of them are required to be present, normally they don't move together. And it's for a real reason. Like if you know about the United States, the president and the vice, they do not even fly on the same plane. Simple reason. In case of accident, you don't want to lose the two top officials of your country. So in the same way, they seldom get together. Of course, at the White House, you see the two of them, or if there's a campaign they are going. Other than that, officially, they always apart. So in the same way, I think we can begin to develop that culture that the president and the vice president do not disappear at the same time. And if for good reasons they have to, then the speaker steps in. So in a way, I can understand the judge's proposal. It makes sense to me. But I think he also used the argument of the independence of the judiciary. I don't think that's a strong one because the independence is still there or it's not there. And so that wasn't a strong argument. But I think for me, for strategic reasons of security, it's important that we limit it to these three top officials. Also, there was a point you were going to make earlier about the suggestion by some of the nominees regarding the tenure of the president. In other words, yeah. And I think I like the way, I don't remember the names of those nominees, but the articulation on that point was spot on, that the Constitution says after 2 terms you are out. So the nominees confirmed that that is what they are going to respect. But of course, don't also forget that in other countries where the breach has been made, normally the president gets parliament to quickly amend the law or wherever for them to proceed then to ask for a third term. But in our case, I think this particular provision is entrenched. If it is, then the process is such that I don't think it's possible. But even then, I don't believe President Mahama in any way would like to breach this convention that we have established.
Well, Prof, very interesting issue. Some will deem it controversial, though. The age of majority is 18, yet to consent to sex, you have to be 16. What's your take on that one? Because, I mean, I'm baffled that, you know, the constructors of the law, I mean, they put the consent of sex at 16, but then the age you can marry is 18. And this also came up at the vetting, and there were varied views on it. And one of the judges actually questioned, can the children wait till 18 to have sex? What's your take on that?
Well, let me confess to you, my governance expertise does not include the governance of sex. So I may not be able to. But
it concerns all of us and our children and grandchildren.
That's right, that's right. But I think that was on a lighter note. The thing is that, look, these days it's almost difficult. It's almost impossible to restrict sex to below 16 because we know stories come out all the time with girls much younger or boys much younger than 16 still engaging with sex. I think the burden falls on families, on parents, and how they bring up their children. And if in fact the churches are still strong in preaching morality and that kind of stuff, that is where it should be. Because certainly the state has no way of determining who and when and how sex occurs. I don't believe that's the issue.